Serial number 11 with serial number 12, MA number 77 of 16 with MA number 76 of 16. Mr. Ashutosh Anand.
In both the cases, the owner has died, my lords, and I received the details of the legal heir. The
How much time you want?
My 2 weeks, my lord.
Please discuss after 3 weeks of the request of 3 weeks of the request of
Both
for the cases.
Serial number 13, MA number 79 of 16, Mr. Alok Lal for the appellant.
In this case, he was taken for vacation, but the service of notification application that has been done, and we have filed an affidavit to this record. That is on record. Notice is 2020.
The notices have been published in terms of Order 5/21-A of the CPC. Also, an affidavit to that extent has been also filed by the council appearing on behalf of the filed by the appellants. Thus, the service of notice on the respondent number 1 to 6 is valid.
The service of notice upon the respondent number 1 to 6 is valid. Good stuff.
How many days delay?
How many days delay?
Delay is about 2 days. That's my record.
What is the
Paragraph 7 stated that the process got lost in transit.
got lost in transit, vigilant in delay of filing this appeal. First time. Next, but after hearing the counsel for the applicant, as no one appears on behalf of the respondent, I am inclined to allow this IA as sufficient ground has been shown to control the delay controlled. I allow this case under the admission.
Serial number 14, 89 of 16, Mr. Rajesh Kumar, Ms. Jaswinder Majumdar, Mr. Rishabh Kamal for the appellant.
Your Lordship, I am appearing in this case, Your Lordship.
Yes.
Yes.
There is a defect, Your Lordship. The petition can file the petition. Sir, 32 days. Delay in filing of this application, Your Lordship.
39 days.
39 days.
What is the ground?
What is the ground?
There are 39 days in delay in filing this appeal. Learned counsel Mrs. Majumdar. Next paragraph. Learned counsel Mrs. Majumdar appearing on behalf of the applicant. By referring to paragraph 3, 4, 5, 6.
By referring to paragraph 3, 4, 5, 6.
Has submitted that the applicant had to obtain some documents and also as the applicant belong from a poor family. Necessary funds were arranged, which consumed some time. First up, next, but after going through this application, I'm inclined to allow this. Allowed as sufficient ground is shown. Yes, this is for enhancement.
Yes, this is for enhancement.
Yes.
Yes.
Mrs. Majumdar?
Mrs. Majumdar?
Mrs. Majumdar?
Yes, sir.
Mrs.
This is for
Majumdar,
enhancement.
this is for enhancement.
Yes, sir. Explain, Your Lordship, the claim has been allowed to the respondent number 2 to the tune of 69,375, which we have challenged. It's not for enhancement, Your Lordship.
Okay. Who are you? You are the owner.
Who are you? You are the owner.
We are the owner.
Who are
You
you?
are the owner.
You are
So
the
it has
I'm
been,
owner.
So it has
the
been,
liability has been saddled upon you.
the liability has been saddled upon you.
Yes, sir.
The vehicle was not insured.
The vehicle was not insured.
The vehicle was not insured, Your Lordship.
Okay.
Okay.
Insurance party was not insured because it was not insured, Your Lordship.
We'll hear this.
We'll hear it.
Serial number 15, ML number 400 of 16. Mr. Sheikh
Notice to
Sinha.
Delay of 9 days, my lord.
Will you have 9
9
days?
days. 9 days, my lord. ताला आपने तो 4 है.
Who is appearing?
Who is appearing?
Shriram General?
Shriram
General?
General.
You appear on behalf of Shriram General?
Shriram General.
My lord.
Because Mr. Ashutosh Anand accepts notice on behalf of Shriram
Notice
General.
on behalf of
So
Shriram
subject
General.
para. There's a delay of 9 days.
There's a delay of 9 days in filing this appeal.
The, from perusal of the petition,
Perusal of the
filed under section 5
filed under section 5
of the Petition
of
Act,
the Petition Act.
I find that sufficient ground has been shown
shown
to the, control the delay of,
on the delay of
to control the delay of
9 days.
9 days.
9 days
As the appellant was
suffering
from some ailment. Prayer allowed, IA allowed.
Uh, 18 years actually, my lord, his age was. But in the post-mortem report, 16 years it was found.
So it was 16
Thereafter,
years.
my lord, he
What
was
other documents you have produced to show the age of the deceased to be 18 or 19 years? What was the qualification of the deceased?
the evidence of the witnesses will
What
show,
is the
my lord.
qualification of the deceased?
Lordship,
What is the qualification of the deceased, Mr. Sinha?
my lord, that is not mentioned, but it is mentioned that he was working, my lord, he was in the business of selling ready-made garments to supply, my lord. The business was to supply the ready-made garments, my lord. This was his business.
Yes, Mr. Ashutosh Anand?
Lords, I don't have a copy of the brief or anything, my lords.
This can be resolved in a Lok Adalat. Mr. Sinha, hand over a copy to Mr. Ashutosh Anand. This case will be listed on Tuesday.
My lord.
Hand over a copy, list this case on Tuesday.
My lord, can you send it to me by scanned copy itself today itself so that I can immediately send it?
You
That
talk
will
to
be
him. You talk to him. Yes.
Serial number 16, MN number 4 of 16, Mr. Ramashwar Singh, Ms. Nanda Kumari for the appellant.
Who is appearing? No one appears at John.
Serial number 17, MN number 542 of 16, Mr. Sachinandan Das, Mr. Pradeep Kumar Chatterjee for the appellant.
In this case, I am appearing for the appellant.
Yes.
On last appearance, 14 February 22, the limitation was found on it was auditive test for admission.
This case has been wrongly listed under the heading for admission. Full stop. When the delay was already condoned on next matter, when the delay was already condoned on the IA on 14/2/2022, it was incumbent upon the office to list this case under the heading for admission. Full stop. The stage had changed as the IA are listed for orders. Once the stage have changed after disposal of the IA, as the IAs are disposed under the heading for orders. Full stop. The IA is disposed, the two have to be listed under the heading for admission. Full stop. Office to be careful in future.
Right.
Serial number 18, MN number 553 of 16. Mr. James, Mr. Manoj Kumar Das for the appellant.
Lordship, I am appearing for the appellant claimants. This appeal is the parents of the deceased. There is delay of 105 days in filing this appeal, and on the previous occasion, the claim notices were directed to be issued by both persons to the opposite parties, the respondents. Steps has been taken, and from the cause list it appears that the insurance company has appeared. Name of Mr. Ghosh.
The liability is upon whom?
The liability is upon the insurance company.
Yes, Mr. Ghosh. Is a delay?
My lord. Yes, my lord.
What is your objection? There's a delay of 105 days in preferential appeal. Full stop. Next problem. Mr. Banerjee refers to paragraph
5, Lordship, of the interrogatory application.
And submits that it is the parents of the parents of the deceased who has filed this appeal. They are poor persons, and they arranged for some fund and approached this court to file this appeal, as their son has expired out of the accident, arising out of the accident. Considering these submissions, I find that sufficient ground has been shown, delay condoned. List this case list this case on Tuesday. If there is a possibility of settlement,
If a proposal, Mr.
let's work out.
Yes, sir. I will also take instruction on this from my clients.
Yes.
And if Mr. Ghosh comes with some proposal, then can we?
Let us see. Yes.
Great.
Serial number Number 584 of 16, Mr.
May I
Anand Kumar
please,
Sinha.
may I please, my lord? I am appearing
Yes.
for the appellant, my lord. This
Yes.
appeal was admitted, my lord, and notices were issued. LCR was called by the order dated 27 to 2017.
Who is respondent number 9?
Lalu Bhattacharya, my lord.
Who is he?
My lord, he is the son of the person who has executed the will, my lord.
So he has not appeared.
Not appeared.
Issue notice. Issue notice to respondent number 9 in his present and correct address. Requisites within 3 weeks.
My lord.
Requisites within 3 weeks.
Deeply obliged.
Serial number 20, MA number 618 of 16, Mr. Suraj Singh for the appellant.
But I am appearing for the appellant, but I had taken steps of notice upon respondents on 27th of February 2018. Thereafter, the matter was listed on 6th of March 2019. On that day, my lord, respondent number two's service report was not received, my lord. It was order was for awaiting service report of.
Fresh notice. Both processed. Respondent number 2 requisites 2 weeks.
Much obliged, my lord.
Yes. Next.
Serial number 21, MA number 651 of 16, Mr. Nikhil Ranjan for the appellant.
My lord, in this case, very small point of future prospects is involved. On the last occasion, Your Lordship directed me to, Your Lordship directed to issue notice. Notices were filed on OP number 2, my lord.
Your Lordship, in this case, pay and recovery has been granted, and we had made an offer of 4 lakh lump sum award, amount, Your Lordship, over and above.
The owner has to pay it since recovery is there.
Yes, Your Lordship, owner is required.
Fresh notice upon respondent number 2. Both process requisites 2 weeks.
My lord, may direct for substituted notice by way of paper publication because, my lord, twice notices have been issued, my lord.
Why should I direct? It is you to file the petition.
My lord, I will do that.
Okay, then on the request of the learned counsel for the appellant, this case is adjourned for 2 weeks.
My lord, I will do that in the meantime. Obliged, my lord.
Serial number 22 with serial number 23 with serial number 24 with serial number 25. MA number 365 of 18 with MA number 366 of 18 with MA number 367 of 18 with MA number 357 of 19. Mr.
Your
Rajesh
Lordship,
in all the cases.
I am appearing on behalf of the appellant, Your Lordship. This case has come for the condonation of delay, Your Lordship.
These are all
First
for
case-
enhancement, Mr. Amresh.
No, Your Lordship, not for enhancement. It is filed by the insurance company.
Oh, this is filed by the insurance company.
Yes, Your
The
Lordship.
notices are in all the cases.
Notice
there's a
are
delay.
already gone, Your Lordship. May
Notice
kindly see
served.
the last order, Your Lordship, 10/8/2021, Your Lordship. A report has called for the lower court, Your Lordship, for the service authority. That let a report called for from the learned registrar of the civil court Asansol with regard to service report upon the respondent number 4, and further, Your Lordship, let the report of the before this court within a period of 2 weeks. The registrar civil court Dhanbad should explain that how the report has been submitted by the process server, namely itna, that these persons have left the address and nobody disclosed the correct and present address of the claimant, though the claimants have preferred execution case number itna pending before the court. May kindly see. Report has come or not, I don't know. And delay is only 39 days.
Who is appearing for the claimants? Who is appearing on behalf of the claimants? Yes.
One name, Your Lordship, has appeared in the cause list, Nikhil Kumar Mehta. Maybe on behalf of owner or claimant, I don't know. I have not gone through the court record.
Who is Nikhil Kumar Mehta?
Nikhil Mehta represent owner or claimant, Your Lordship.
Well, yes, Mr. Nikhil Mehta. Yes, Mr. Nikhil Mehta, he's on. Mr. Nikhil Mehta. There's some.
As per I understand, Your Lordship, Nikhil Kumar Mehta appeared on behalf of the owner, Your Lordship.
First is Ved Prakash Mathur.
In
Mr.
three
Nikhil
cases.
Mehta, you are appearing on behalf of the owner.
Lordship.
I think, Your Lordship. On three cases, Your Lordship.
Lordship, I am appearing for the owner, Lordship, Ved Prakash Mathur.
Ved Prakash Mathur.
Yeah. In case number 365, it's respondent number 5.
In all the cases, Mr. Amrit Kumar, in all the cases, execution has been preferred.
Yes, Your Lordship. All three cases, Your Lordship. First three cases, stay is already granted, Your Lordship. And on 21/2/2019, Your Lordship. And only case number, Your Lordship, 25 serial number MA 357/19, I have filed for stay of the execution proceeding, Your Lordship.
Hear this on Tuesday. We'll hear this on Tuesday. We'll hear this case on Tuesday. Awaiting appearance of the respondent.
Obliged.
Obliged, Lordship.
Serial number 26, MA number 74 of 21, Mr. Amit Kumar Das, Mr. Saurabh Kumar, Ms. Swati Chalini.
Your Lordship, both process notices were filed on 23/9/21, Your Lordship, and there was a direction by Your Lordship to deposit the entire amount, and that has been deposited, Your Lordship, before the Registrar General.
Who is respondent number 3? Your prayer is? Challenging liability.
Lordship, I'm challenging the liability as well as the quantum as well, Lordship, because the disease was a management trainee. So instead of 50% future prospect, 40% future prospect ought to have been given, Your Lordship. And that makes a substantial difference, Your Lordship.
Management trainee where?
Management training in Pantaloons, Your Lordship. And that has been observed, Your Lordship, in internal page number 12, Your Lordship, running page number 39, last paragraph. But from scrutinizing of both these documents, it appears that the letter of offer was issued to Amit Kumar Deceased from Pantaloon Retail Limited Future Group Venture on 4th July 2008 for his appointment for the position of management trainee for annual total employment cost of rupees 2,75,000 with bonus of rupees 75,000. And Your Lordship, in page number 14, internal page number 14, running page number 41, first line, 50% of income of the deceased to be added towards future prospect. That is our contention, Your Lordship. He was a management trainee.
So what do you mean by management trainee? He's not an intern. It's a management trainee. He will be, after training is completed, he will be permanent. It's a nature of job. He cannot be said to be.
In service
Madam,
matters, Your Lordship, automatic confirmation to the post of a trainee is that has been held is not automatic. From a trainee to the permanent job, it is a trainee is not a permanent nature of job, Your Lordship.
It's a permanent job. Once the pay scale has been given, it is a permanent. Whether the word used as trainee or it is temporary, it's absolutely a different thing.
May I say something?
How many instances you want to see where the person is after completing 30 years of service retires and the government comes up with and the employer comes up with a plea that he has not been confirmed in service? How many instances you know?
But
there are several like this.
If the management trainee dies during the period of training, it cannot be considered as a permanent.
It is not. It's not that. It is. What do you mean to say? It's a self-employed?
No, he was not self-employed.
What are the categories as per Pranay Shetty judgment?
One is the self-employed on a fixed salary, and there is a permanent job.
He's not a self-employed.
He is not a self-employed, Your Lordship. However,
as per the Pranay Shetty, then in which category he will fall? If he doesn't fall within employed,
not salaried.
He will fall under salary, though not a permanent.
Then,
since he was a bachelor, my lord, 50% has also been deducted. Only.
This is the ground.
Yes, my lord. Parents are 70 years old, my lord, and that is why I filed an IA for disbursal of the amount, my lord. Only son, only earning member, my lord.
So why this case has been listed today?
My lord, I mentioned it for
I are questioning the liability also.
Yes,
Madam?
Your Lordship.
On what
Yes,
ground?
Your Lordship.
On what ground?
The vehicular documents has not been produced, Your Lordship.
None of the vehicular documents have been produced.
Yes, Your Lordship.
They did not appear also.
They did not appear also. And we also wrote letters to the owner, Your Lordship, for production of the document before the learned tribunal, but he did not appear, neither the documents were produced before the learned tribunal.
And now this is listed for what purpose?
My lord, see para number, page number, internal page 11, which wherein the court below discussed.
Your IA number?
My lord, IA for disbursement of amount.
This IA number is 7240 of 21.
Delay also.
There is a, yes, Your Lordship, there is a delay of 236 days. IA is
236 days. Full stop. 236 days in filing this appeal. Full stop. The learned counsel appearing on behalf of the appellant submits by referring to paragraph number 5, 6, 7, 8, 9 that the delay is not intentional and was beyond the control of the appellant. He submits that next paragraph. Considering the aforesaid paragraphs of the submission, I find that sufficient ground has been shown to condone the delay. Delay condoned. Full stop. IA allowed. Next paragraph. IA number 740 of 2021. Yes. What amount has been deposited?
Entire amount, my lord. After hearing all these points, your lordship directed that amount should be deposited. This point was also argued about salary.
This IA number so this IA has been filed with the claimant, praying therein to withdraw the amounts of compensation deposited before this court pursuant to the order dated. Pursuant to the order dated.
My lord, it is annex 21/9/2021, annexure A.
2021. He submits that the claimants are the old parents of the deceased.
Yeah.
And they were solely dependent upon the income of the deceased.
Only child, my lord.
As he was the only child. Full stop. They submit that the deceased was unmarried. Full stop. He submits that now the deceased, the appellants are the respondent claimants have no other source of income Yes?
Yes, my lord. They are 65, 62 years old. My lord.
They are senior citizen and need monetary help. Thus, the amount so deposited may be disbursed. Full stop. Next para. Yes, what do you have to say?
Your Lordship, if quantum is not the ground, that can I have? Then only for pay and recovery, the owner may.
Concept of the applicant submits that the quantum is on the much higher side. Full stop. Next para. From the argument advanced on behalf of the parties, I find that an amount of rupees, how much deposited?
Your Lordship, 59,41,284. White check number
59,
59
41,
lakh 284.
84,
White check
plus
number 6
2 lakh
and
20,
136.
136. 61 lakhs, 61 lakhs 16,420 has been deposited before this call. First up, considering the aforesaid fact, I direct the Registrar General to disburse an amount of 50 lakhs in favor of the claimant. Full stop.
My lord.
The balance amount of 11,61,420 should be kept in an interest bearing account by the Registrar General.
Your Lordship, only my averment regarding the management trainee may kindly be recorded in the order sheet. And name of Mr. Amit Kumar Das and my name.
That portion, I am not hearing the appeal finally. You for issue notice, next for issue further notice to respondent number 3 by both process. Requisites 3 weeks.
Your Lordship, notices were filed, most probably if.
Yes, what has appeared? So fresh notice. Fresh notice. Full stop. List this case after receipt of the service reports.
Obliged, Your Lordship.
Shall I furnish the bank account details to the registrar?
Or caretaker registrar is directed to? Registrar is directed to disburse 50 lakhs. The bank details, the claimants will be at liberty to furnish the bank details along with the IFSC codes, etc. Etc. Full stop. The claimants will also furnish a cancelled check of the bank account, which of the bank. Okay. Of which their account, of their bank account, cancelled check of their bank account before the Registrar General.
Deeply obliged, my lord.
Yes.
Under the heading for admission, serial number 27, MN number 2050, Mr. Abhay Kumar Mishra, Mr. Manoj Kumar Chaubey for the applicant, Mr. Ashish Kumar Thakur, Mr. Sarfaraj Akhtar for the respondent.
May I please, your lordship, this case was earlier heard, my lord, on 8/2/2022. My lord, the case is that the charge sheet was submitted against the, my lord, another vehicle, which the petitioners appellant are not the insurer. My lord, therefore, and also in the FIR, it was alleged that the driver of this vehicle, the appellant's insurance vehicle, was not, my lord, on default. Therefore, the impersonment, my lord, liability cannot be fixed upon the appellant truck, my lord. So the respondent has taken adjournment in this case, my lord, to seek instruction.
Who is the respondent?
My lord, appearing, my lord, because this is a contest between insurance companies, my lord. Whether I will have to pay or whether the impersonment division will be done, my lord, or my lord, the bus which was also involved, that insurance company has to pay.
Mr. Counsel, what did the tribunal held?
Tribunal was given the finding in favor of the appellant insurance company, my lord. Even the police, my lord, the charge sheet was also submitted, my lord. The entire finding is in favor of the, my lord, appellant insurance company. Therefore, my lord, I am assailing.
Charge sheet is not a substantial.
No, my lord. The finding is also in favor, my lord. Yes, my lord. So we'll see, my lord.
Let us see where is the finding.
Yes, my lord.
Which paragraph? Where is the issue so framed?
Issues start, my lord.
Let us see the issue which was framed by the tribunal.
Case 22, my lord.
Issue number 5.
Yes, my lord.
Was the truck trailer? Or issue number 8. Yes. Let us see. Where is that issue? Okay, issue number para 18.
Yes, my lord.
My lords, in this case, if I am permitted to make a submission, my lords. Copy was served upon me, but my name is not appearing, so I could not mark the list, my lords. And I have intimated the insurance company I am yet to seek, yet to get instructions. Only for not today I was praying, my lords. Copy was served upon me, my lords. But my name is not appearing, my lords. I could not mark the list, my lords. Only for not today I was praying, my lords.
Just a minute, let's see.
Page 26, my lord. The issue which I am arguing was dealt with.
Yes. Who is the
Lordship?
Mr. Mishra?
Yes, my lord.
Just switch off the other device which has been switched on in your office. Is any other device switched on there?
No, my lord. I am on the computer only, my lord. Means only one device, my lord.
Who is the you are the insurer of the bus?
Bus, my lord.
Who was the insurer of the truck?
My lord, the Manish Kumar, my lord, the insurance company of the which appeared by represented by my lord. They have been, my lord, given instruction to take instruction.
What instruction they will take? Mr. Manish Kumar.
My lords.
Come to page 26.
National Insurance Company.
Come to page 26.
My lord's copy I have already sent to the insurance company.
The manner of accident.
Yes, my lord, that I have verified. Therefore, on the last date, I had taken time, my lord, so that I could seek instruction, my lords. Unfortunately, my lords, I could not mark the list, my lords. Only not today, I pray, my lord, let it be tomorrow, my lords.
And now this is a dispute between two nationalized insurance company.
Yes, my lord, yes.
Both settle the matter in the Lok Adalat.
Yes, yes, my lord. Yes, my lord.
The dispute is between two nationalized insurance companies. Next para. The counsel for the appellant submits that from the judgment it is clear that the accident was caused by the rash and negligent driving of the truck, which was admittedly insured with National Insurance Company Limited.
Yes, may I just interfere for a moment, my lords? I'm up here claimant. If you lordship to kindly see the remaining paragraphs of the same page number 26. OP number charge whom Mr. Manish Kumar represent, whether the vehicle was insured by it or not was doubtful. Therefore, it was held that therefore at this stage the OP number 4 is not held liable to indemnify the OP number 3.
Wait.
Because it was doubtful, my lords.
And if it is doubtful, then the owner have to pay, my lord, when that vehicle was not insured.
So the recording by this honorable court may be, my lords.
No, just a minute. Then why it is? Let's see. And why? How it is doubtful?
On the plain statement of the OP number 4.
How can that be?
I'll just read 3 more paragraphs from the subsequently. So far, OP number 4 is concerned, it has disputed the fact of insurance, and also the insurance policy, and OP number 3 has not come up with any document in this regard. The document of insurance which is available on the record is quite vague and it is not legible. The plea of OP number 4 that in absence of any proper policy number or proper legible document is unable to say as to whether the vehicle was insured or not appears to be genuine. Therefore, at this stage, OP number 4 is not held liable to indemnify the OP number 3. So this fact also Mr. Manish Kumar would require to needs to be verified.
On the request of the parties, list this case after 2 weeks.
Oblige, lords.
Yes, ma'am. Oblige.
Serial number 28 with serial number 29, MN number 377 of 16 with CO 34 of 21. Mr. Vibhas Sinha for appellant in first case, Ms. Rakhi Rani for appellant in second case, Mr. Chandrajit Mukherjee, Ms. Amrita Kumar, Ms. Rakhi Rani, Mr. Mukesh Kumar Banka for respondent in first case, Mr. Vibhas Sinha, Mr. Chandrajit Mukherjee for respondent in second case.
Well, the appeal is preferred by the insurance company against the award, and the cross objection is filed by the claimants for enhancement of award.
What is your ground in the appeal?
That's my ground. Besides the other grounds, my lords, my other important ground is with respect of right of recovery. The owner has neither pleaded nor has produced the vehicular documents. And despite this,
owner has not even appeared.
Owner appeared, filed a written statement. My lords may see the written statement. Only points were given that the vehicle is insured and its registration number is such and such. Kindly come to page 25.
No, let us see the written statement of the owner.
And they have not brought on record the vehicular documents.
Owner has appeared.
Owner has appeared, my lords. There.
No, before this court.
Yes, my lords.
This court is also appearing.
Yes, my lords, I appear.
Yes, Mr. Mukherjee. Yes, Mr. Mukherjee, tell me.
Since the vehicle was insured and the accident occurred during the period of insurance, my lord.
So, but if the vehicle was being driven by a person without a license, then the driving license has been marked as Exhibit 2, X by 2.
driving license, my lord, so kindly come.
Who is the deceased? Who is the deceased?
But that's the
This
fact
is
of
Azad Bhushan. Vijay Bhushan Azad,
Okay, and the offending vehicle is
a tanker.
driven by
That's- That detail is not with me, my lords.
he must have been made a party to the proceeding.
not made party in the claim proceeding.
Yugal Prasad Mandal.
His license is on record, Mr. Vivasana.
But his driving license is not on record. Other vehicular papers are not on record. Tankers.
His driving license is marked as X by 2.
But let's kindly see this driving license, which is marked as X by 2. Kindly come to page 10, paragraph 10.
Date of accident. Give me the date of accident.
The date of accident is
11
11
4 15.
11/4/15. So it is valid up to 11/7/17.
But the driving license, besides driving license, the other vehicular documents were not produced.
What do you want the other vehicular documents? Tell me.
But the permit has to be there. The RC book has to be there.
It is already on record.
But nothing is marked exhibit.
It's Evidence Act strictly applied before
No. Evidence Act does not strictly apply, my lord.
Then Exhibit X is there, the payroll, exhibit. These documents are there. The documents of the vehicle of the tanker is there.
That is the fitness certificate, insurance policy.
Fitness certificate is there. Goods carriage permit is there. Everything is there.
But since I have not seen the LCR, I can only read from paragraph 10. So once I have to inspect those documents, my lords.
Goods vehicle belong to?
One Anup Saria.
Yes, it was
Anup Kumar Saria.
Product. Permit validity 14 to 19. Exhibit X by 5. Yes, Mr. Sinha. And what is the ground for enhancement?
Your Lordship. Your Lordship, on the conventional head, Your Lordship, meager amount of has been awarded under the conventional head, Your Lordship. And Your Lordship, interest part, Your Lordship. I'm only concerned with interest part and the conventional head.
I won't interfere with the interest part. I will not.
Your Lordship.
I'll not interfere with the interest part.
Your Lordship.
Malus, the cross objection they have filed after 2 years, 3 months from the date of appearance.
Your Lordship, regarding this
cross objection, I can take cognizance if the compensation.
Larger relief, as per my lords, the judgment of Honorable Supreme Court in the case of Ranjana Prakash, the larger relief, the paragraph 7. I am reading only the relevant line.
Yes.
But my understanding it cannot be. Paragraph 7.
Yes.
This principle also follows from Order 41, Rule 33 of Code of Civil Procedure, which enables an appellate court to pass an order which ought to have been passed by the trial court and to make such further or other orders as the case may requires, even if the respondent had not filed any appeal or cross objections. This power is entrusted to the appellate court to enable it to do complete justice between the parties. Order 41, Rule 33 of the Code can, however, be pressed into service to make the award more effective or to maintain the award on the other grounds or to make the other parties to the litigation to share the benefits or the liability, but cannot be invoked to get a larger or higher relief. So it can be inter say 50%, 40% between the insurer and insured. It can be that award is 40% against the insured, now it is reduced. But the claimants, in absence of that, cannot get the larger relief what they have never pressed upon, because cross objection is arising out of the grounds of appeal. Mallards may only see that part of the judgment, Mallards.
There is other judgment after this.
Yes.
So on last occasion, Your Lordship, Learned Counsel was relying on the judgment reported in 2011, Volume 6, FCC 321, Your Lordship, and I had taken time to assist Your Lordship on this judgment.
There are different points. There is a different points. Now there are other judgment which says in the appellate stage also just and proper fair compensation can be granted. Is it not?
Your Lordship.
Well, it's just and fair compensation can certainly be granted, but the question is whether they have assailed that part of order or not. And even if their contention will now today be accepted, award will be rather reduced. I can show that how it can be reduced, my lord.
Oh, show me.
Yes, my lords. My lords may straight away come to running page 29 of the memo of appeal, the last paragraph.
Yes.
My lords, they have not produced income tax return. What they have produced is the salary slip, fourth line of page 29.
Yes.
Exhibit 1 is salary slip of rupees 31,202 per month.
Yes.
Based on this, every calculation is made. As per Pranay Sethi, paragraph 59, salary means salary minus tax. Now my submission is, with respect of assessment year 2015-16, it was an accident.
The deceased was?
Deceased was the public servant, police constable. So certainly he was paying tax for it.
So?
But the income tax has to be deducted. And for up to 3 lakhs, it's nil. 3 to 5, 10% of amount exceeding 3 lakhs. So if 10% amount exceeding 3 lakhs will be deducted, their award will be reduced to 45 lakh 22,000, which is now presently 45 lakh 52,000. Approximately 35,000 rupees will be reduced. After giving all benefits, 30% future prospect, 1/3.
What is the age of the deceased?
Yes, Maharaj?
What was the age of the deceased?
43.
43.
Multiplier of 14 he will get. And as per the judgment of Pranay Sethi, he will get 30% future prospect. Everything, even if calculated in terms of Pranay Sethi and Sarla Verma.
We'll see. You want to go through the lower court record to go through those documents?
Yes, I have to go through it.
When do you want?
But after 1 week, any physical.
No. Where is the amount lying?
But we have deposited the entire amount before the trial.
Your Lordship.
So we have deposited earlier. We have deposited 23 lakhs on 8/3/2017. They have already taken, and thereafter on 25th February 2022, the balance amount of 31 lakhs 69,925 we have deposited.
Your Lordship, one thing I would like to submit, Your Lordship.
Yes.
Your Lordship, in pursuance of Your Lordship's last order, Your Lordship, 10 weeks time were granted, Your Lordship, was granted to them, Your Lordship. They have filed beyond those 10 days, Your Lordship, and Your Lordship, in the joint name of the deceased claimant, Your Lordship, as well as the surviving claimant, Your Lordship.
But for that, they have to substitute the name of the deceased person in the executing court itself. How can we alter the award which is assailed before this honorable court?
Which claimant is there?
But 2 persons have died. Now they say only 1 person survives. That is respondent number 2, Nitish Raj. So if we have already deposited check there, if they can substitute the same person in the execution proceeding itself, the check will be revalidated and fresh check will be filed. They haven't taken any step before the executing court for that.
The proceeding of the learned court, executing court was stayed, Your Lordship. That's why name of one of the respondent could not be deleted, Your Lordship. And Your Lordship, if they would have deposited within those 10 days, Your Lordship, it could have been done, Your Lordship, but they have deposited on 25th February, Your Lordship. And Your Lordship's last order was to deposit immediately and inform this honorable court within 10 days, Your Lordship.
14th
I'm
on the
not able
request
to
of
hear, Your Lordship.
on 14th, madam. We'll hear this.
Serial number 30, MN number 419 of 16, Mr. Amit Kumar Das, Ms. Shruti Shrestha.
Your Lordship, in this matter, the entire awarded amount has been deposited as per the direction by Your Lordship on 27/8/21, and both process notices were issued, Your Lordship.
Anyone appearing?
I'm going for the claimant, Lordship. Number 1 to 3.
What is your ground?
Your Lordship, the vehicle was being driven for illegal purpose, Your Lordship. And then the accident took place while it was being restrained from going from the restricted area, and the constable died because the vehicle did not stop. So our main contention is when the vehicle is being used for an illegal purpose, then insurance.
What was the illegal purpose?
Your Lordship, that is internal page number 4, Your Lordship. We are running page number 22. It was carrying illegal coal, Your Lordship. May I read, Your Lordship?
When the inspector tried to stop him, he ran over the inspector.
Yes, yes, Your Lordship.
So you are praying for a recovery.
Yes, Your Lordship. We say that insurance company is not liable to indemnify in such matters where the vehicle is being used for the illegal purposes and not under as per the schedule.
They are recovered.
Lordship. And the owner appeared before the tribunal, Your Lordship.
Owner appears before this court?
Yes.
Who is
No,
appearing?
not.
Who is appearing for the owner?
One name is coming, Anisul Zama Khan.
Yes, my lord. I am appearing for the honor, my lord. Respondent number 4, my lord.
Okay. Where is the evidence? This here. The counsel for the appellant insurance company submits that the vehicle was being used for unlawful purpose. He submits that the vehicle was transporting illegally mined coal, and when the deceased, who was a police official, wanted to had taken steps to stop the same and intercept the same, he was run over by the vehicle. She submits that in view of the facts, aforesaid fact, the insurance company is not liable to indemnify the owner of the vehicle. She submits that the right to recovery should have been granted to the insurer. Considering the nature of next line, considering the nature of allegation, it is necessary to go through the lower court records. We'll stop for the lower court records.
Serial number 31, MN number 463 of 16, Mr. Manish Kumar, Mr. Amit Mishra, Mr. Rajesh Kumar Singh for the appellant, Mr. Anjali Kumar for respondent.
May I please, my lords? In this case, my lords will find the ground of appeal is that the deceased along with 10-12 persons were riding on a my lord's gratitude on a goods carrying vehicle, my lords. Specific plea was taken, even evidence was laid, issue was framed, but it was decided against the company only on the basis of one statement given by the witness that the policy did not debar my lords carrying passengers. Whereas it is a goods carrying passengers, in this case, LCR will be required, my lords. I am relying upon the judgment of Honorable Supreme Court in which 30 to 40 persons were traveling in the truck and it was claimed that they were, my lords, owners of the goods, which was the same defense here also. And the Honorable Supreme Court said that it is not possible to, my lords, presume all such things because 30 to 40 persons cannot travel along with their goods in the truck, my lords.
The counsel appearing on behalf of the appellant submits that the deceased was a gratuitous passenger. Thus, the insurance company is not duty bound to indemnify the owner of the vehicle. Next para. Considering this submission, it is necessary to go through the lower court records. Let's call for the lower court records. You have satisfied the award?
In absence of any direction, what's award having? If you satisfy pilot direction, because it will only be that much. No quantum, we have not challenged the quantum.
There's an order.
I don't think there is any order. Had there been any order, then we would have complied. Yes, there is order, my lords. The stay has been dismissed, and I have instructed the petitioner to, my lords, deposit the amount, my lords. It will be deposited by this month, my lords. On 15 to 22 order was there, my lord.
Next.
Serial number 32, MN number 503 of 16, Mr. Sam Nasaria, Mr. Ajito Sen, Mr. Akash Bhushan, for the appellate, Mr. Rajesh Kumar Mahta, Mr. Ajit Kumar Sinha, Mr. Manish Kumar, Mr. Amit Mishra for the respondent.
Lordship, this appeal is filed for modification of the interest portion. No reason was assigned by the court below why interest was not granted from the date of filing of the case.
It was granted from where?
No interest has been granted. Running page 21, internal page 8 of the judgment, last portion ordered. There it is. Within 1 month from the date of award, failing which insurance company will be liable for penal interest 6% per annum from the date of award till realization.
Where is the insurance? Who is appearing for the insurance company?
I am appearing for the insurance company, my lord.
Manish Kumar.
Lords, this is a fact that no region has been assigned, my lords. Otherwise, the award is, my lords, on a higher side because they have claimed 3,300. 50% was enhanced towards future prospect instead of 40%. Then reduction has to be made 1/4, which was done only 1/3. Low amount was paid, my lord, towards this conventional heads, my lords. So overall, the award is just and proper, my lords. Only so far as interest is concerned, admittedly, no region has been assigned.
Appearing on behalf of the appellant submits that he has filed this.
Lordship, I want to submit one more thing, Lordship.
Yes.
Regarding consortium, Lordship, I want to cite one judgment of Honorable Apex Court reported in 2018, volume 18, SCC 130.
Yes.
Where consortium has been categorized into 3 parts: spouse consortium, parentalial, and filial. All the minor child, they are also entitled, and the mother of the deceased, according to this judgment, they are entitled for consortium.
They are entitled.
But here that has not been considered.
The counsel for the appellant submits that he has filed this appeal challenging the part of the award which negated grant of interest to the claimant on the amount claimed as compensation. He submits that no reasons have been assigned as to why interest has not been granted, whereas in terms of section 171 of the Motor Vehicle Act, the claimants are entitled to receive interest. Yes, whether there was any delay on your part, which can be attributed to you?
No, Lordship, there is no delay because there is no delay on my part.
He also submits that the records will suggest that the appellants have not contributed to any delay in disposal of this claim application, which was filed in 2010 and disposed of in 2015. Full stop. Considering the said submission, LCR is here. I direct the court to immediately transmit the records of compensation claim case number 35 of 2010. Click here. And District Judge 1, come presiding officer, Motor Vehicles Accidents Claim Tribunal, Lohardaga. Yes, Lohardaga to transmit this by by 9th of March, so that the case can be listed again on 10th of March. Let a copy of this order be immediately faxed to the Principal District and Session Judge Lohardaga for immediate compliance. By special messenger.
May I submit one thing, Your Lordship, in this case, Your Lordship. I am for the Your Lordship respondent, Your Lordship owner. Only not on 10th, Your Lordship. Not on 10th, Your Lordship. Any 14, 15, because that week I may be not here, Your Lordship.
Any liability upon you?
No, not.
You are not a necessary. Then you are not a necessary party. He is not claiming any against you also. Yes.
Offline.
Serial number 33, MA number 534 of 16, Mr. Alok Lal for the appellant, Mr. Kalyan Beneti for the respondent.
But in this case, we are against the award passed by the tribunal. In this case, we have taken a defense that there was no permit and driving license, and in pursuant thereto, the learned tribunal has framed issue number 5 and 6. But
5 and 6.
5 and 6. But surprisingly enough, my lord, kindly come to paragraph 13, where the issues number 5 to 8 has been clubbed together and has been taken at in a one paragraph. The accident, as per the claim application, was that this truck was insured with us, and the deceased, he was on the bicycle which was hit by the truck, insured with us. We are not much on that. Now, in this case, kindly paragraph 3, what it has been discussed by the learned tribunal. These issues are also interlinked, so if taken up together for consideration, in this regard, it is important that the above issues has been proved that the deceased, Azhar Alam, died in a road accident, and the plaintiff number 1 to 5 are the wife, 2 daughters and 2 sons of the deceased, Azhar Alam alias Munnu, and they were depending upon the earning of the deceased. All the 5 plaintiffs are legal heirs of the dependent of these deceased. They are entitled for get compensation. Now the question arises, who is responsible for compensation? It is admitted case of the party that know that on the relevant date and time of accident, the offending vehicle number such and such was validly insured with the Mrs. New India Assurance Company Limited. The copy of the policy number is such and such, valid from this date to this date, and covering the date of occurrence on 22/2/2007. So it is admitted that the fact that defendant number 2 is the insurance of the company, being the insurance of the offending vehicle. Now the question of determination of what now after that, the learned tribunal has skipped the liability and had determined the quantum. Liability part is skipped by the learned tribunal. Only the determination of the quantum has been made. On the quantum part, we have nothing much to say.
So you have satisfied this?
But let me see, my lord. In this case, no, the notices were issued, your lordship, and pursuant thereto they have appeared. We have, when we have challenged the award, perhaps it seems that we have not deposited the amount.
The counsel for the appellant, Mr. Alok Lal, submits that they are not entitled to the company. The appellant is not legally bound to indemnify the owner of the vehicle. He submits that a specific plea was taken in respect of the driving license of the driver of the offending truck, for which issue was also framed as to whether, to the effect that as to whether the truck bearing registration number JH 10K 9367 was insured, 9367 what if it was being driven by a person having valid and effective driving license. He submits that this issue number 5 was not dealt with in the entire judgment, nor any finding has been arrived at. First off, he submits that since there was a specific plea that the vehicle was being driven by a person without a valid license, comma, it was incumbent upon the owner to come up with a positive evidence, bringing on record the driving license of the vehicle. Full stop. Next para. Considering the aforesaid submission, it is necessary, this court feels that it is necessary to go through the lower court record. Call for the lower court records, full stop. Next para. If this court also feels that if this appeal is allowed, at best the right to recovery can be given to the insurance company. Full stop. The insurance company is thus directed to satisfy the award. In the meantime, full stop. List this case after receipt of LCR.
Serial number 34, MA number 540 or 16, Mr. Shankarlal Agrawal, Mr. Abhijit Kumar Singh for the appellant.
Yes, Mr. Agrawal. Where is Mr. Shankarlal Agrawal? Yes, Mr. Agrawal. Mr. Agrawal, where are you? Am I audible? Am I audible?
Yes, sir. No, your voice is loud and clear and visible also.
Okay. Where is Mr. Shankarlal Agrawal? Pass over. Yes.
Serial number 35, MA number 567 of 50, Mr. Anil Kumar Sinha for the appellant. Mr.
But in this case, I would like to request my learned friend to supply me the copy of the award because that has not been supplied to me. I'm having only a memo of appeal.
Switch on your video.
Your Lordship, in item number
35. Please supply me the copy of the
yes,
award.
Your
I don't
Lordship.
have it.
Mr. Aloklal, switch on your video.
No, video is there, Your Lordship. Video is active.
No, it was switched off. Yes, madam. You have filed this appeal for seeking what relief?
Your Lordship, the liability to pay the compensation is on the owner, Your Lordship. I am owner of the truck, Your Lordship, and the tribunal has wrongly awarded this award, Your Lordship, to pay compensation to the deceased, Your Lordship, to the claimant, Your Lordship. My truck was insured, the policy was up to date, Your Lordship, and the exhibit A, which was produced by the insurance company, Your Lordship, which they say that is only the certificate of insurance. It was brought on record, and the whole terms and conditions of the policy was not brought on record, Your Lordship. My driving license at the time of accident was valid, Your Lordship. So the insurance company, Your Lordship, not to the owner of the truck, Your Lordship.
What is the finding to that effect?
But in this case, let it come after some time and I have to arrange the record, Your Lordship. We do not have the record, neither the copy of the award, Your Lordship. I was praying for this.
Your Lordship, in the meantime, lower court record may be called for, Your Lordship. The truck was, Your Lordship, a goods carrier, Your Lordship. The finding of the lower court is, Your Lordship, that they said that the person who died was a gratuitous passenger, Your Lordship. The truck was loaded with brick. The deceased was employed by the owner of the brick, Your Lordship, to unload the brick, Your Lordship. So he is not gratuitous passenger, Lordship. He was laborer at that time.
Let the lower court record be called for.
Lordship.
LCR be called for. We appreciate the contention raised by the counsel for the appellant.
Obliged.
Serial number 36, MA number 664 of 16. Mr. Ankit Kumar for the appellant, Mr. Rohit Kumar, Mr. Sural Kumar, Mr. Ankit Singh.
Lordship, in this case, I am appearing for the appellant.
Yes.
Here the appellant is the owner of tractor, Lordship. The tractor was not insured at the time of occurrence, and this appeal is filed against the order dated 22/6/2016, Lordship, by the tribunal court, where the
You are the
Lordship,
you are the
appellant, Lordship, owner.
owner. So the liability has been fastened upon you.
Lordship. At the time of accident, Lordship, there is two joint owners. I can see the appellant and the police party number Rajkumar Yadav is here appellant, Lordship, as well as Sukhdev Yadav. There is a joint owner of tractor, Lordship, and the name of has been deleted. Right?
You are jointly and severally liable to pay the amount.
Lordship, this issue was raised in issue number 2, decided in issue number 2, running page 20, internal page 3.
Yes.
Was the opposite party Rajkumar Yadav
alias Kumar Yadav, registered owner of the vehicle number such tractor involved in the accident at the time of the accident. And this issue was decided in para 9. Next page, just next page. Beside oral evidence on the point of the claimant filed a photocopy of the owner book of the offending vehicle. For this purpose of inquiry on perusal of the photocopy of the owner book, I find the opposite party Rajkumar Yadav. Kumar Yadav is joint owner of the offending vehicle with the deceased opposite party Sukhdev Yadav. Moreover, this is relevant, Lordship. Moreover, there is no denial on the point by the opposite party in his written statement. Hence, it is crystal clear that the opposite party was registered owner of the offending vehicle at the time of accident.
Who is the deceased?
Who is decided in
Who is the deceased?
the
Deceased was the labor, 28 years old.
What is the name of the deceased?
Dasrath Yadav. That can see in paragraph number 2 at page number 19.
So Sukhdev Yadav died, so his name was deleted.
Not it. Without substituting the.
So pay the amount.
My submission is that since we are the joint owner of the offending vehicle,
You're jointly and severally liable also.
One point is also here, Lordship. May kindly see the page number 7 of my appeal, Lordship.
Yes.
At the time of paragraph number 10, Lordship.
Yes.
That the appellant opposite party stated, Lordship is here. At page number 7, paragraph number 10.
Yes.
That the appellant opposite party stated and submitted that the appellant opposite party that Kumar Yadav, one of the claimant respondent, namely Asa Devi, the wife of the deceased, Lordship, already compromised the matter with the appellant. At the time of accident itself, Lordship, opposite party on 21/1/2010, and after receiving 50,000 rupees, and thereafter she has specifically agreed at para number 3 of the agreement that she would not file any claim at any court as she has received the whole compensation amount that government has not been considered by the lower tribunal court. And
So
other ground is that, Lordship,
you mean to say that
at the time of accident, 50,000 rupees all compensation amount has already been paid to the wife of the deceased, and the agreement was prepared.
You mean to say the appropriate compensation for a death case is 50,000 only?
And
at that time,
mother and father are also the claimant in the court below. They have not compromised.
Yes.
The learned tribunal court. The learned tribunal court not substituted the legal heirs of Sukhdev Yadav co-owners of National Lordship.
Call for the lower court record. Call for the lower court records.
Serial number 37, MA number 34 of 17. Mr. Arvind Kumar Sinha, Mr. Jitesh Kumar, Mr. Praveen Kumar Verma, Mr. Rakesh Kumar Gupta for the appellant, Mr. Abhay Kumar Mishra, Mr. Santosh Kumar Jha, Mr. Krishna Prajapati, Mr. Mahavir Prasad Sinha for the respondent.
I am appearing for the appellant.
Serial number 37.
Let the title appeal has been dismissed for default. Miscellaneous case 2.
Title appeal dismissed for default. Miscellaneous case also dismissed for default.
Yes. No, not dismissed for default. On merit. Kindly turn to page 19. The impugned order dated 4th January 2017.
This is the miscellaneous case.
Yeah. Miscellaneous case before district judge for restoration. That was also dismissed. It is 4-line, 5-line order. May I read it?
The certified copy was sent for correction. Lawyer was never informed.
Who is appearing?
Lord, I am appearing for the landlord, my lord. The appeal has been filed and it was the order was passed rightly, my lord. If Lordship will verify the order which was challenged in the miscellaneous, I have sent on the previous occasion I have sent that order which was challenged in this miscellaneous application. They intentionally, my lord, not taken any step for the removal of the defect. Now the appeal was filed in the year 2013. Now this is 2022, and the almost sufferer is the landlord.
You are still in occupation.
Yeah, my lord, he is in occupation. I am landlord, my lord. Yes, my senior friend is in occupation, my lord.
Still in occupation.
That is why, my lord, this dismissed and the restoration, then if it will be allowed even also, what will happen? The appeal will restored in the year 2013 after 10 years, my lord. Then appeal will be heard and again it will take 10 years, my lord.
So after this dismissal in 2016, you have not preferred an execution case, Mr. Mishra?
My lord, the stay is there, my lord, in this case itself.
It is a house property or a commercial space?
Shop, my lord.
Which place?
My lord, Dhanbad, my lord.
It is a Dhanbad.
Dhanbad shop. How much rent you are paying from disposal?
That I will have to take instruction, my lord, from Mr. Rakesh Gupta.
Mr. Mishra?
Yes, my lord, not less. I think it is, it was considered, it is 100 or 200 rupees, my lord. I am just verifying, my lord, from the the lower court order, my lord.
2017. It was dismissed in 2017.
Yes.
Appeal was filed in 2016. Dismissed in 2017. Okay. Okay. 18, 20, 21, 22. 5 years. 5 years means 60 months. What is the area of the property?
Rent is only 21, my lord.
21.
Mr. Rakesh Gupta.
Rupees.
21 rupees.
Yes, my lord.
What is the area of the? What is the area?
Area is, my lord. It is.
Area of the shop room, Mr. Gupta?
Yes. Yes, my lord.
Area of the shop room.
I'm also not aware with this fact, my lord. I'm just calling, my lord, to the
plane ticket now.
Planes, go through the plane.
Few seconds.
Go through the planes.
Plane देखना, plane है आपके पास?
Yes, my lord. Plant in the sir, plant in the record, my lord. In sir record.
What were the defects?
My lord, they themselves has taken, my lord, adjournment for removal of defects. Thereafter, they did. Yes, my lord, defects, my lord, where? My lord.
My lord, I've just contact to the client. He said the area is about 200 square feet and rent was last only 30 rupees, 32 rupees.
Which area is it?
About 200 square.
Bankmore, my lord.
Bankmore?
Yes, my lord.
I can restore it.
My lord, in that case also, my lord,
Listen to me. Subject to two conditions, and both the conditions have to be complied with.
That we are ready, my lord.
Payment of cost of rupees 2 lakhs.
2 lakhs.
2 lakh.
Too much.
And the appeal will be heard and disposed of within a month.
my lord, we are agreeable. My lord.
2 dates will be given to you. Despite the defects, the appeal will be disposed of. If you don't appear on both these 2 days, it will be decided ex parte against the appellants. These are the two simultaneous conditions. $200 square feet of shop roof in Bankmore. The average rent from the date of dismissal of the miscellaneous appeal. And when was the suit dismissed?
My lord, 2013, my lord. The order itself says, my lord, the impugn order here in the miscellaneous, my lord, in this case itself.
Title appeal was filed in 2013.
Yes, my lord.
And it was dismissed when? It was dismissed when?
22/12/2015, my lord.
22/12/2015.
Yes, my lord.
So it should be, yes, it's 2 lakh rupees. That will pass an order?
My lord, it may be reduced for some amount. It's too much for the
Don't pay, vacate.
party.
Vacate. Vacate.
My lord, as your lordship, you passing the flexibility. I will ask to pay the amount.
You will have to pay the cost.
Take down. The appellant has preferred this appeal against the order dated 4/1/2017, passed by the Principal District Judge Dhanbad in civil miscase number 5 of 2016, by which the aforesaid miscellaneous case has been dismissed. First step. Next para. The senior counsel for the appellant submits that the order dated 4/1/2017 is bad, and an opportunity should have been provided to the appellant to contest the case on merit. He submits that the order by not restoring, the order dismissing the miscellaneous case amounts to not restoring the title appeal, not restoring the title appeal 104 of 2013, which was dismissed, will amount to non-restoring of so and so, which was dismissed for not removing the defects pointed out by the Sarastadar. First up, he submits that the order is too harsh and the appellant will suffer irreparable loss if this appeal is not allowed. So next panel. Mr. Abhay Mishra, appearing on behalf of the respondent, submits that the suit was filed for evicting the appellants, which was decreed. It is submitted that thereafter a title appeal was filed in the year 2013 on 18/11/2013. Full stop. He submits that purposely the appeal was filed defective and was kept defective Full stop. He submits that in spite of direction given by the appellate court, the defects were not removed. Thus, the court had no other option than to dismiss the appeal for not removing the defect on give me the date, Mrs.
Order sheet लगा हुआ order.
My sound has not gone. 22/12/2015.
On 22/12/2015. Full stop.
Order sheet.
He submits that thereafter, this tenant filed civil miss case number 5 of 2016 for restoring the title appeal. But the state application was filed on 28/1/2016. चलिए 28/1/2016 after expiry of the limitation period. Full stop. The appeal was dismissed on 4/1/2017, fine 17, as there was no merit. Full stop. He submits that in order this instant miscellaneous appeal was filed on 16/1/2017. Full stop. The counsel for the appellant submits that the tenant is still in occupation of the tenanted premises in question, which is in a commercial locality of Dhanbad, and is paying and the rent of which is paying how much rent?
Last rent was 32 rupees only.
And last rent paid was rupees 32.
Okay.
32 for an area of 200, approximately 200 square feet. Next. Considering the submission of the appellant and the respondents, I find that the title appeal number 104 of 2013 was dismissed as the defects were not corrected, was not rectified. Full stop. This dismissal is dated 22/12/2015, against which the miscellaneous case number 5 of 2016 was filed for restoration. Full stop. The miscellaneous appeal was considered by the principal district judge and was dismissed on 4/1/2017, holding that even after giving opportunity to remove the defect, the appellants did not remove the defects for 11 months. 11 months. Full stop. This clearly suggests that the defendant, being a tenant, wanted to remain in possession of the property in question by any manner. Full stop. The appeal was dismissed, the miscellaneous case was dismissed, and the appeal was not restored. Full stop. Against this appeal was filed. This miscellaneous appeal has been filed. Full stop. Considering the facts of this case, this court feels that one opportunity should be given to the appellant's tenant to contest the case on merits. Thus, this appeal is allowed. Title appeal number, the order passed in miscellaneous civil miscase number 5 of 2006, order dated 4/1/2017, passed in civil miscellaneous case number 5 of 2016, is set aside, and consequently, title appeal number 104 of 2013 is restored to its original file before the principal district judge, Dhanbad. LCR यहाँ है. Full stop. The next para. This will be subject to a payment of cost of rupees 2 lakhs. अच्छा, 1,50,000 कर दे रहे. 1,50,000, which has to be paid, which must be paid before the next date of hearing to be fixed by the principal district judge. Full stop. The appellant will appear along with a copy of this order before the principal appellant and the respondent. Both will appear principal district judge Dhanbad within 15 days from today. Full stop. On receipt of the copy of this order, either from the side of the appellant or from the side of the respondent, the tribunal, the principal district judge will fix a date of hearing, which will not be more than 20 days. Full stop. Thereafter, the title appeal should be heard and decided by the appellate court within a period of 30 days thereafter. So it is 45 days.
Yes, my lord.
30 days thereafter, full stop. It is made clear that if any of the parties do not cooperate in the hearing, the trial court, the appellate court will proceed ex parte against them and will finally decide the appeal. Full stop. This execution case will remain, no, you will not proceed? You will not proceed?
My lord, for the 45 days, my lord, the fate of the appeal will now come, my lord.
Full stop. The interim order staying the execution case, interim order passed by this case, passed by this court on 13/2/2017, staying further proceeding of execution case number 674 of 2014, thereby vacated. Full stop. The counsel appearing on behalf of the respondent undertakes that the respondent will not proceed with the aforesaid execution case for for the next 60 days.
Obliged, Your Lordship.
For the next 60 days. First up, it is made clear that after 60 days, the landlord will be free to proceed with the execution case.
Obliged.
Much obliged, Your
Clear.
Lordship.
It is made clear if the amount of 1,50,000 is not deposited within the first date of hearing, on or before the first date of hearing fixed by the appellate court, it will be open to the landlord to proceed with the execution case immediately, and also proceed to recover the full stop, the amount of rupees. If the amount of rupees 1,50,000 is deposited, the same should be immediately disbursed to the landlord. Full stop. If the amount is not deposited, we will proceed with the execution case, and the appellant's landlord will be at liberty to recover the same by the due process of the court. The court will recover the same as a due towards land revenue by initiating an appropriate proceeding.
Want to clarify in the form of my lord was one last.
Yes.
Want to clarify that in form of DD or in the cash amount has been deposited.
How can it be cash? It will be demand draft or a draft or anyway when you can deposit.
Any manner, my lord, that is to be decided by the principal district judge, my lord.
And let this order, this case is allowed, let this order be faxed to the principal district judge Dhanbad immediately. But your time will start after 15 days, not from the date of receipt of the fax. You both will produce.
Obliged, Lord. I will, my lord.
Yes.
Much obliged, Lord.
Heard Senior Advocate Mr. Manjul Prashad on behalf of the appellate. Yes, next.
Serial number 38, MA number 39 of 17, Mr. Ramchandra Sahu, appellate, Mr. Vikas Kishore Prasad, Mr. Naveen Kumar for the respondent.
My lord, I appear, my lord, in this matter on behalf of the appellant. My lord, this miscellaneous appeal, your lordship, has been directed, my lord,
yes,
against the, my lord, the order dated 19th of August 2016, whereby,
yes,
my lord, the grant of probate has been dismissed.
Probate has not been granted to you.
Yes.
Yes, let us read the judgment.
Yes. My lord, so far as the properties, your lordships are property is concerned, my lord, details of which has been given at schedule A.
Let us see the judgment. Let us see the judgment.
Yes. Yes, my lord. I am reading it, my lord.
Yes.
Instant probate case has been filed by the above named petitioners against the state of Jharkhand on 4/5/2010 with a period to grant the probate of will dated 23/8/1994 executed by Mosmat Punia in Devi in favor of the petitioners. It has been asserted that in probate that the will dated 23/8/1994 is the last will and testament of the deceased Mosmat Punia, wife of Bhatu Mandal of village Kathwada, PS Jamua district Giridi within the jurisdiction of this court, executed in the favor of petitioners, namely Puran Prasad Mandal and Sitaram Mandal, both sons of the Badri Mandal, resident of the village Kathwara, PS Jamua district Giridi on 23/8/1994 at Sub-Registry Office, Jamua. This Puran Prasad Mandal and Sitaram Mandal are the petitioners before your lordship. That the property is described in the will laying the jurisdiction of this court and the same has been described in Schedule A, B and C. It is further asserted that the said deceased Mosmat Bunia had died leaving behind the nearest relation as the only daughter, namely Dhalia, the mother of the petitioners of the village Kathwara, PS Jammu Gir district, and same has also been described in the genealogical table in Schedule B. Value asserted is of 30,000 only. The said will dated 23/8/1994 has been prepared under the instruction of deceased Punia, and the same has been read over and explained to her in the local language, and executed the will after full understanding the documents in presence of Ramdev Mahto, son of Jhupar Mahto of village Biro Singha, PS Jammu district Giridih thereof, and the identifier and witnesses signed the deed of the will under the instructions of deceased Mosmat Punia at Sub-Registry Office Giridih. It has been asserted that as per the best knowledge of belief of the petitioners, no application yet has been filed by anybody to any other court for probate or letter of administration of the said properties, and there is no collusion of filing of this petition. It has been further asserted that Mosmat Punia acquired 63.5 decimals of land through her Khatiani Rayat in the name of Dego Sundi, her father-in-law, in Khata number 51 at Moja, Kathwada, Gaddi Kisko, PS Jammu district Giridih, whereas acquired 40 decimals of land in Khata number 33/49, Thana number 269 through a settlement in the name of Dego Sundi, her father-in-law, in the year 1991. That Mosmat Punia also came in possession of land under Khata number 38 and 38/69, Kevat number 1, Tawji number 13, Thana number 266 through the settlement in the name of her husband in the year 1983-84, and thus acquired 7.29 decimals of land, more fully described in the schedule, and she acquired a will and she executed a will of the aforesaid property and land in schedules on 23/8/1994 in the favor of Puran Prasad Mandal and Sitaram Mandal, the petitioners. It has been asserted that the cause of action arose on 38/96 when the Mosmat Punia died, and on 29/11/2002 when the petitioners got the registered will dated 23/8/1994, and thereafter only day to day within the jurisdiction of this court. Lastly, it has been asserted that the petitioners are ready to deposit the court fee regarding this application. The following properties has been shown as follows. Schedule A, land of Khata number 51, plot number 527, 528, 19.5 decimals in Moja, Kathwara, Gaddi, such and such. Khata number and plots details are there. Then the Schedule B, land situated at Mora Paradi, Jammu district such and such, Khata number such and such, plot number such and such, area details. Khata number 38 of 71, plot number such and such, Baidyanath Ram, Patti such and such. In response to the petition of probate dated 4/5/2010, the opposite party, Jharkhand, state of Jharkhand, has filed rejoinder by way of so cause with a prayer that under the facts and circumstances stated in so cause, the application of probate only may be disposed according to law. It has been asserted by the OP in their so cause that the application for probate is not maintainable, but the petitioners are required to prove their.
Mr. Sharma, you need not argue. Where is the judgment?
My lord.
Where is the judgment of the Supreme Court?
That the title is not to be decided in the probate proceeding.
This is the only thing.
Yes. Judgment I will supply you, Lord.
I'm appearing on behalf of the respondent estate, my lords.
Yes. Yes. What do you have to say?
My lords is absolutely correct in saying that in probate case,
I'm not saying anything. This is the law.
Title, absolutely, my lords. Lords, I concur to the views.
Set aside.
I should.
That judgment, your lordship, I am supplying. I will send it on mail. Yes.
Give me the reference.
Yes.
The court found that there was a testing witnesses are there. Where is the LCR?
LCR नहीं आया है, इसको मंगाया जा सकता है.
देखिए तो call for the lower court records of probate case number 5 of 2010 from the court of the district judge to Giridih, by special messenger. List this case next week. Let a copy of this order be immediately faxed to us. You should be ready with those judgments.
Yes, my lord. I was ready, my lord, but that I could not send it. I will send it.
इसमें दीजिए तो। Is this? Copy the local records. Yes.
Obligement.
Serial number 39, MA number 254 of 18, Mr. A.K. Sahni, Mr. Vikesh Kumar for the appellant.
Yes, Mr. Sahni.
Yes, Your Lordship, Mr. Sahan. I am for the appellant. Mr. Sahan is joining, Your Lordship.
Yes, Lord. I am appearing on behalf of the appellant, Lord. In this case, the appellant has challenged the order dated 5th of March 2018, whereby the application filed under Section 278 of the Succession Act has been letter of administration has been rejected only on the ground, my lord, that it is a suspicious case. Whereas the lordship will find the facts on record, which has not been disputed by any person, that on 26/6/1951, husband of the deceased, my lord, purchased a land, my lord, and the deceased and the appellant were the legal heirs. Then on 11/2/2015, a will was executed by the deceased in favor of the present appellant. Then on 26/1/2016.
What is your relationship?
Cousin, that is my nephew. She was issueless. Now, my lord, she died, my lord, after 9 months, after 11 months of the execution of the will. That is on 26/1/2016.
Nephew from whose side? From your side or your husband's side?
The husband's side. Husband's side. It
Nephew
has come.
of the side. Nephew of the husband's side.
Husband's side.
Then even if there is no will, the property will default upon you.
Yes, yes. Otherwise.
Otherwise
Yes.
also.
Yes. Now see, he is a class 1 year. In absence of class 1 year, he becomes the class 2 year.
There are other nephew or nieces?
That has not come, but nobody has objected.
So you have not made them a party?
Because it is not necessary, it is party to in general. Because in letters of administration.
In general also.
Yes, but nobody, your lordship may kindly appreciate, this proceeding was initiated, my lord, in 2017, and it was decided after a year, my lord, on 5th of March 2018. Your lordship may kindly see the 4 witnesses were examined. PW1 is signatory on the will, which was executed in his presence on 11/2/15 in presence of Jayalal Munshi, and the deceased put her LTI. That is his statement. Paragraph 9 of the trial court judgment. Then, my lord, PW2, he said, my lord, appellant used to look after the deceased, and last ceremonies were also observed by him. That is exhibit 1 by 1.
Who is PW2?
PW2 is the villager.
Any relative of the deceased examined?
Relative, my lord. PW3 and 4, they are the witnesses to the will.
I'm asking.
In fact, it has not come on the record to suggest who are the relatives and what is the genealogical table of the deceased.
Applicant, you come to para 8, it says that the applicant died issueless, but on the text page it has been mentioned that the applicant is Devar's son of the...
But that is nephew. Devar's son from the husband's brother's son.
It has been implemented as a case.
In the background, paragraph 8, page number 3, inner page 3 of the judgment.
So why the other brothers and sisters of the deceased or the nephews have not been made a party?
Because there had been no objection from any corner.
No.
Because there had been no contest on behalf of any other legal heirs.
Made them a party. You just tell me who are the legal heirs. What are the deceased? What is the name of the deceased?
Yes, deceased was the Astava Devi. Astuba Devi.
Astuba Devi's husband name is?
Astuba Devi's husband, wife of late Dhana Sahu, Dhana.
So Dhana Sahu has definitely got brothers, sisters?
I do not have such personal idea, because the judgment does not say anywhere, or the pleadings also does not disclose anything.
Seek instruction.
Yes,
Seek instruction.
Yes, but the only basis to reject is paragraph.
So this gives a doubt. This raises a doubt, genuine doubt that you are hiding someone who could have.
Had there been any contest, it would have been the prime duty on the part of the appellant to array them implead them as a party. But there has been no contest.
So how do I know that they have not contested? The best way is to implead them a party, and they will say that we don't want to contest. This is the best way.
Had there been any other the legal heirs?
Mr. Sahar, not bringing the legal heirs on record. See, your father is definitely alive. Who is a brother of that person?
My father, yes.
Yes, then there may be other brothers and sisters.
That may be, but I do not know at the moment. And even the will does not show anything with regard to the others. Even the application under section 276, which is with me, because the case
are the class 1 or class 2 legal heirs of the husband of deceased Astuva Devi.
Yes, ma'am. Wife of Dhana Sahu.
Whether that is Dhana Sahu.
Widow of Dhana Sahu. Yes, ma'am.
Widow of late Dhana Sahu. They will also
if any.
Details, if any. List this case after 4 weeks. In the meantime, call for the local records.
It was called for by order dated 21/9/2021.
Here is here.
Oblige.
Yes.
Serial number 40, MA number 348 of 18, Mr. Amit Kumar Das, Mr. Anjali Kumar, Ms. Uda Kumari, Ms. Swati Shalini.
Lordship, I am praying for a short passover of 2 or 3 cases, Your Lordship.
What is your ground for appeal?
Lordship, my ground for appeal is in the judgment it has been stated that the driver of the said vehicle was not having a valid driving license, and it has come in the judgment.
Where is that issue?
Lordship, para 12, issue number 4. Lordship, there is a IA that is pending. Sir, for grant of stay. Sir, for grant of stay.
Where do you want to stay?
For
Well, satisfy the owner. At best, you can get a right to recover the amount from the owner. Nothing more than that. Where is Mr. Das?
I am praying for a short passover. He'll assist Your Lordship after 2 or 3
cases.
Serial number 41, MA number 343 of 20, Mr. Aishwarya Prakash, Mr. Praveen Akhori for the
Milords, I'm appearing on behalf of the appellants, Milords. This appeal has been filed against the motor accident claim case number 17 of 2017, Milords.
Yes, this for enhancement.
No, Milords, not for the enhancement, Milord, the payment of the insurance
Oh, you are
claim,
the
Milords.
state.
State, Milords.
So on what ground you are
DFO.
challenging your liability?
Milords, there are three grounds, basically three grounds. First is, Milords, that the vehicle was registered with the state of Jharkhand, Milords, and DFO Chatra, who has to pay the insurance amount, Milords, is not the insuring authority, Milord. The government of Jharkhand, the additional finance commissioner, government of Jharkhand is the actual department who has to pay the insurance amount. Second, Milords, the deputy commissioner represent the state, Milord. But he has not been made the party in that case, Milords. And moreover, Milords, in the issue number 2, which has been decided by the learned court below, while deciding the motor accident claim case, which was whether the death of Dinesh Mahto at about 3 p.m. was due to rash and negligent driving of the driver of Bolero bearing registration number Ratna, wherein he has hit and died on the spot. The finding part, Milord, at page 20, at page 21, Milords. That the IO, the investigating officer, the police has submitted the final form against the deceased himself under section such and such, showing lack of evidence against the driver of the offending Bolero.
Yes.
Lords. Lord, that was
Admittedly, the vehicle belongs to the government of Jharkhand.
Milords. There's no dispute to the fact, Milords.
Now tell me, who has approved filing of this appeal? Who has approved filing of this appeal?
Mr. DFO Chatra, Milords. So far, the signature is.
You have a cell which approves.
It was filed in 2020, Milords. Some other.
Where is the Advocate General? Where is the Advocate General?
Lords. He must be in some court, Milord. I'm not sure, Milords. I will.
Tell him to connect. Tell the Advocate General to connect. Have you paid the amount or not?
Milord, the amount has not been paid, but we are ready to pay. The DFO, so far the info has been received, Milord. Instruction which I have received, Milord. We are ready to pay the compensation amount, Milord.
Who is for the claimants? Who is for the claimants?
London Advocate General is not picking up the call. He is rejecting it. But I have messaged him on WhatsApp with meeting code, asking him to appear in court.
Where is Ashutosh Anand? He is the additional Advocate General.
Milords.
LCR दीजिए. What is your ground, Mr. Ahmed? What is the ground of filing this appeal?
Lord, there are the grounds are set at Milords at Round 12. 14 rounds out first. May I be permitted, Lords? Lord, the learned court below committed error in distinguishing the fact that as to who will pay the compensation. As the opposite party number one is not a registered owner, he was only authorized to use the vehicle. And
So divisional forest officer is not a part of the government.
he is a part of the government, my lords.
Mr. Ashutosh Anand,
My lord.
an accident had taken place involving a government vehicle.
My lords.
The vehicle was used by the government agency, the government department, that is DFO. Your DFO was made a party. The DFO appeared in the claim case before the tribunal, admitted that the vehicle was a government vehicle and was being used by the DFO. Switch on your video.
My lords.
Was being used by the DFO. The tribunal awards compensation, holding that the vehicle was being rashly driven by the driver. There was license, there was no violation. And since the vehicle was a government vehicle, there was no question of insuring the same. Now your plea, one of the plea was that the investigation pursuant to the criminal case arising out of the accident, a final form was submitted exonerating the driver. Now, there was an eyewitness to the occurrence who was examined before the tribunal who said that it is because of the accident, rash driving of the driver, which has accident has occurred. Now, you did not, court holds that you have not given any evidence, nor even brought in the IO, nor any other person who can say that the vehicle was not being driven. Solely now, this appeal has been filed solely on the ground that the IO has exonerated the driver in the charge sheet, and on the ground that the vehicle was registered by the government vehicle. Deputy Commissioner was not made a party, so we are not liable to pay. To me, these grounds are absolutely frivolous ground to file an appeal. You are the DFO, the respondent is the district forest officer, divisional forest officer, an officer of the state using the state vehicle. Admittedly, the vehicle belongs to the state, and you have filed this appeal. You have not produced any witnesses. Charge sheet is not a substantial piece of evidence on fact. You are relying on it. You have not even brought on the IO also to be cross-examined, that how he comes to the conclusion that the driver was not driving the vehicle in a rash and negligent manner. So don't you think that this is a frivolous appeal which has been filed to defeat the claim of the claimants?
My lords, may I just be permitted to examine the records first, then I'll be in a better position, my lords, to make a submission. My lord, but
and if I have to dismiss this, it will be with heavy cost. If I have to dismiss this, it will be with heavy cost. When do you want?
My lord, next week, my lords, next Monday, subject to lordship's kind consideration.
Next Tuesday. Let's name of additional Ashutosh Anand appear in the cause list. List this case on next Tuesday on his request.
I'll just request my brother to, like, he can send a file, copy of the file.
Between you, both are state. The appeal is from the state.
Yeah.
All sort of, who permits to file these appeals?
My lords, many a times, because just off the record, I may permit to say so, my lords. I've seen many a times, even while working with the insurance companies, my lord, if there's, though insurance company has not led any evidence, my lord, but since in the charge sheet, there's a concept of exoneration. So
This is a state. State has filed this appeal. Tell me.
my lords.
This is a state. Who decides that appeal should be filed against which?
My lord, the initial opinion is rendered by the concerned GP who handles the matter, my lord. Subsequently, it is sent to the forest officer. Thereafter, the file moves up to the law secretary, and then the opinion is the final opinion is the final call is taken.
Final opinion.
That I need to verify from the records, my
Verify
lord.
it and tell me.
My lords.
Serial number 42, MA number 3 of
Blind lots.
Mr. Alok Lal, Mr. Santosh Kumar for the appellant.
Malad, in this case, Malad, may I pray one thing, Malad, let this matter come after 4 weeks because my file is messed up somewhere. So in the meantime, I'll take the steps of notice upon the respondent.
No, let us see what is this ground.
My file is mixed up with some other papers, my lordship.
Magma.
Yes, lordship.
Magma insurance.
Magma, yes, Magma insurance.
Let me go through it.
Only scanty papers are with me, your lordship. Or in the next week, subject to lordship's pleasure, your lordship. Perhaps the right of recovery is not in the proper manner, as far as I could recollect. He was traveling on the tractor, fell down.
Let me go through it.
Yes.
Yes.
Well, let it come in this after some time because I
Why
could not.
disposed of? The court in paragraph 10 in several subparagraphs of paragraph 11 has held that there was a violation of the policy and specifically has, while deciding the issue number 2 and 3 in paragraph 11.5 has ordered that you can recover, the right to recovery has been given to you, but on the award portion that line has not been incorporated.
Yes, that is what.
I'm incorporating it. I'm modifying that. I'm
And one
incorporating.
more thing, Manoj, subject to lordship observation, because there is one the judgment of the Honorable Supreme Court which has been passed in MS High School versus HDFC Irco General Insurance Company Limited. Perhaps that is not reported. It is SLP number 31406 of 2017.
Yes, send me.
In this case, your lordships have held, perhaps uh, we do not find any ground to interfere of this appeal. The High Court has rightly held that once there is a breach and condition of the policy, the liability cannot be fastened on the insurer. The High Court has relied upon a decision of this court in the National Insurance Company Limited with Chala Bhartamma and New India Insurance Company with Asha Rani. So therefore, these two judgments, which has been relied upon by the Honorable Supreme Court MS High Schools, that clearly speaks that in cases of gratuitous passenger, the liability cannot be fastened upon the insurance company.
Pay and recover.
No, that is not even that. Not even that. That is not even that. Pay and recovery is also not there.
It has been held that pay and recover cannot be ordered.
Well, this is what I have to see, Malad. This is what I have.
Please, Mr. Likhe. Heard the learned counsel for the appellants.
Malad, this judgment may be referred to. Malad, this judgment by this order may be referred to, Malad.
Show me that order.
I'll be sending it right now, my lord. I'll be sending it right now, your lordship.
Send it.
I'm sending it right now.
Send it. Like you heard the counsel for the appellant and heard appellant first up. The appellant is the insurance company here who has challenged the award dated so and so passed by so and so. First up, Mr. Alok Lal, counsel appearing on behalf of the appellant submits that admittedly the deceased was a gratuitous passenger, and in that view, the insurance company should not be saddled with the liability to pay that amount of compensation. He submits that the tribunal has held in several subparagraphs of paragraph 13 of the award, 11 of the award, that the vehicle was being driven without a valid and effective license and without a permit, and thus the insurance company has to pay the compensation amount to the claimant with the liberty to recover the same from the tractor owner, but in the award has omitted to incorporate the said.
But I have sent it on the WhatsApp of the court master, George.
He submits that whatever as it may, since the insurance company is not liable to indemnify the owner, the principle of pay and recover will not be applicable in view of the judgment passed by the Honorable Supreme Court in the case of so and so versus so and so, and it is only the owner who has to pay the amounts. Next paragraph. After hearing the counsel for the appellant, I find that the point for consideration in this appeal is very short. Also, admittedly, the offending vehicle, which is a truck, which is a tractor bearing registration number GH05BM 4481, was insured with the appellant insurance company. The tribunal, just like these are the only point raised by the insurance company. The tribunal, while considering the tribunal, while deciding the issues involved in the before the tribunal, has framed issue number 6, issue number 4, issue number Roman 4, which is as follows: quote, whether owner of the vehicle has violated any terms and condition of the insurance policy, including requirement of valid driving license. Full stop. Look, all the issues have been wrongly indicated. In paragraph 6, the aforesaid was the issue as issue number 4, but the numberings of the issues got changed in the finding portion. And the issue has been answered as issue number 2 and 3 in paragraph 11. First stop. In paragraph 11, the tribunal has framed the two issues which are as under paragraph 11, bold issue. First stop. While deciding the same issue in paragraph 11 point Roman 2, the tribunal has held that adverse inference can be drawn that the offending tractor was being driven by a driver without any valid and effective license, and it was plying without any valid permit. Further, in 11 Roman 3, the tribunal has held that there was violation of terms and condition of the policy by the owner of the offending vehicle, as the permit was necessary and the tractor was being driven without a permit. Further, in paragraph 11 Roman 4, the tribunal has, relying upon the judgment of National Insurance Company Limited versus Swarna Singh and others, 2004, volume 3, SCC 297, has held that even though finding that it was, even though it was the liability of the owner of the tractor to pay compensation, but the insurance company is directed to pay the compensation amount to the claimant with the liberty to recover the same from the owner. First step. Ultimately, in paragraph 11 Roman 5, the tribunal has again held that the appellant has to pay the compensation amount, whatever decided by the court, by the tribunal, to the applicants with a liberty to recover the same from Gopal Chandra Datta, within bracket OP number 1, the owner of the offending tractor, full stop. Full stop. Thus, the tribunal has already given the right to recover the amount of compensation from the owner of the vehicle. Full stop. Next paragraph. The counsel for the appellant relied upon an order passed by the Supreme Court in SLPC number 31406 of 2017, and submits that since the liability is not upon the insurance company cannot be directed to pay any amount and recover the same. Full stop. The said, after going through the said order dated 22/11/2017, I find that there is nothing to suggest that the Honorable Supreme Court has laid down a law to the extent that there cannot be pay and recover when there is a violation of policy, when there is an admitted violation of policy. Full stop. Thus, since no law has been laid down, the order passed by the Honorable Supreme Court in the SLP C number so and so versus so and so, that is 31406 of 2017, is not applicable in this case. Full stop. The law which is applicable in this case is the judgment of the Honorable Supreme Court in the case of, which has been delivered in the case of National Insurance Company Limited versus Swarna Singh and others, which has been relied upon by the tribunal. Full stop. First of this uh, this principle of pay and recover is being followed by several is followed in the several other judgments passed by the Honorable Supreme Court. So this court is following the same principle also. So the tribunal has also followed the same principle, and this court is also following the same. Next paragraph. Though from the award, from the judgment and the award, I find that though in several paragraphs of subparagraphs of paragraph 11, the tribunal has held that there was a violation of policy and the insurance company should pay and recover the same from the owner, but in the award portion has not incorporated the aforesaid order. This may be by way of sheer inadvertence. Thus, this court holds that the insurance company will pay the amount of compensation so decided and so adjudicated by the tribunal and recover the same from the owner of the vehicle, that is, will be at liberty to recover the same from the owner of the vehicle, that is OP number 1 before the tribunal, namely Gopal Chandra Datta. First up, with this aforesaid observation, this appeal is disposed of. Yes. Switch on.
Statutory amount. Statutory amount.
Statutory amount. The statutory amount may be refunded to the insurance company.
Just one thing I would like to add, Your Lordship. One of the Swaran Singh case is on the point of driving license, and Asha Rani is on the point of traveling with the gratuitous passenger. So my contention before Your Lordship would be, but just for a moment, contention would be, because in case of Swaran Singh, it can be distinguished in this way, but in that case, Swaran Singh, the premium was taken, the policy was there, but there was a violation of the condition of policy. And in Swaran Singh case also, Their Lordship in the last paragraph have held that this should not be treated as a precedent. So my case, in this case, this stands totally on a different footing on the point of gratuitous passenger, because in Asha Rani, the Asha Rani has not been unsettled in Supreme Court with regard to Swaran Singh case, with regard to the right of recovery, because the absolute.
There are other judgments also in case of gratuitous passenger that you have to pay and recover. There are other judgments of the Honorable Supreme Court also.
That is true, my lord.
That
there are two possible methods in admission.
okay, thank you.